Welcome to today's seminar on latent conditions. My name is Rawia Ayache. I'm a principal lawyer at Doyles, and I'll be taking you through the presentation today. Okay, so let's get stuck into it. Latent conditions. All right, so this seminar will discuss understanding latent conditions, the legal principles, risk allocation, contracts, claims, and practical management. When we talk about latent conditions, we're drawing on decades of experience. Doyles has advised the Australian construction industry since 1991 across contract drafting, project delivery, security of payment, dispute resolution, and strategic commercial advice. As the slide says, our experience includes construction contract drafting, negotiation, project delivery, and advice. And it's this background which is what informs today's session. Okay, so the legal principles and how risk is allocated is one of the topics we'll be discussing, how to manage them practically in construction contracts, claims, and on site, and we'll discuss what's important. So, what are latent conditions? A latent condition is essentially a site condition that couldn't reasonably have been anticipated before a contract. The key phrase here is could not reasonably have been anticipated by a competent contractor undertaking reasonable pre-contract inquiries. Latent condition clauses determine who pays and who gets time when something unexpected is uncovered. And so the legal distinction is crucial. Contract typically only allows faithful latent conditions. So why they matter? They matter because latent conditions commonly cause cost blowouts, program delays, extensions of time, and disputes between contractors. And what are they? They are hidden. So latent versus patent conditions. Latent conditions are hidden. Patent conditions are visible. If you could have seen it or reasonably discover it, it's patent, and you generally wear the cost. So this slide captures it well, hidden and unforeseeable based on the information reasonably available before the contract. And importantly, contract typically only allows for claims for latent condition. Why they matter? Latent conditions are one of the biggest drivers of cost blowouts and delays. They lead to EOT claims, disputes, and arguments about entitlement. And as this slide says, they are commonly cause of cost blowouts, program delays, and risk allocation affects tendering, pricing, insurance, and due diligence. Modern procurement models design and construct ECI fast track push contractors to price with incomplete information. Contractors rely heavily on geotech reports, utility data, BIM models, and consultant investigations. The key point here is modern procurement changes where risk is assumed, not necessarily who bears it. So careful drafting remains crucial. In the historical context, traditionally, under the common law, the contractor bears the risk in the lump sum contracts. Modern contracts try to balance the fairness with commercial certainty, and this slide summarizes it. Traditional common law position, the risk lies with the contractor in lump sum contract. So what are some common examples on projects? There are usual suspects: buried asbestos, unknown services, unexpected rock, groundwater, reactive soils, archaeological finds. These examples help anchor what we mean by latent. Okay, so what's the common law position? Unless the contract provides otherwise, the contractor wears the risk. And the courts generally enforce the parties' agreed allocation of risk, even where the outcome appears commercially harsh. So this slide highlights the key questions the court asks. Is there a specific latent condition clause? Are exclusion or disclaimer clauses in play? Was reliance on the principal's data reasonable? Okay, so the default position of responsibility, fixed price contracts confirm the contractor assumes the site risk. The Walker versus Council of Municipality of Randwick case is one of the foundational cases on latent conditions. The contractor here hit more rock than expected and argued that the tender documents understated the quantity. The issue was the contractor entitled to a variation? The court didn't accept the contractor's argument because it was a lump sum contract and the contractor carried the risk. The judgment makes it crystal clear at paragraph 84, which says the plaintiff's obligation to complete the work for the agreed price was not affected by the alleged understated statement in the plan. So here, the takeaway is simple. Under a fixed price contract, unless the contract gives relief, the contractor wears the risk of the unforeseen site condition. So rejection of implied terms for latent conditions relief. In the case of Doyles Construction versus Down, this case reinforces the principle that courts won't imply term to rescue a contractor from latent conditions. Here, the contractor argued that adverse ground conditions justified extra payment. The issue was whether the term could be implied to compensate for latent conditions. The court said no. The express term governed. Justice Hardy put it plainly, a party who has contracted to carry out building work is duty-bound to satisfy themselves of the nature and the characteristics of the land. So if the contract doesn't provide relief, you can't rely on an implied term. You must investigate the site. So moving on to principles, disclaimers, shielding against risk assumption. The Morrison-Knudsen versus Commonwealth case is all about disclaimers and misleading information. Here, the contractor relied on geotechnical data in tender documents that turned out to be inaccurate. The Commonwealth tried to rely on the disclaimer. And the issue was the Commonwealth liable for misleading representations, or did the exclusion clause prevent the plaintiff suing the Commonwealth for negligence? The High Court said that the disclaimer didn't actually exclude the responsibility for the accuracy of the information. As Justice Giggs said, it does not amount to a disclaimer of responsibility for the information itself. And the lesson here is that disclaimers must be clear and effective. If the principal provides information, they may still be responsible for the accuracy. So frustration only applies to radically different performance. Cadelphi Construction versus State Railway Authority is the leading case on frustration. The contractor here was prevented from working at night due to an injunction, making timely completion impossible. And the issue was the contract frustrated? The High Court found that it was frustrated. And the key principle is that frustration only applies when performance becomes radically different. As the judgment put it, frustration occurs when circumstances render it a thing radically different from what was undertaken. It's rare in construction, but Cadelphi shows that it can happen where an unforeseen legal event fundamentally changes the performance. No relief for impracticality absent clear clause. In this case, Teeth encountered soil conditions that made excavation far more difficult and expensive. They argued for an implied term allowing relief. And the issue here was there an implied entitlement to an additional payment? The court rejected that argument. The contractor allocated excavation risk to the contractor, and the court emphasised that the appellant is entitled to no extra payment because the work may prove more expensive than expected. So this case reinforces that if the contract allocates the risk impractically or increases the cost, it won't give rise to relief. Okay, so misleading side information and contractor reliance. In Abbey Group v Sydney Catchment Authority, this is one of the more important cases about misleading conduct in construction. Here, Abbey Group was awarded a lump sum contract to construct a new spillway at Warragam Dam. The tender documents stated no plans existed for the outlet pad. In fact, a 1951 plan did exist, and unexpected excavation required 180,000 cubic metres, which was expected. The contract expressly allocated latent conditions and documentation risks to Abbey Group. So that omission led to massive additional excavation. And the issue was, did the failure to disclose the 1951 plan constitute misleading and deceptive conduct under the Trade Practices Act? And could that conduct override the express risk allocation clauses? The Court of Appeal found that the omission was misleading and induced the contract. And as the slide notes, the omission of the 1951 plan was misleading. Key point here is statutory misleading conduct under the ACL or the TPA can override contractual risk allocation clauses. Okay, so just shifting from courts to the contract, the cases discussed demonstrate one consistent principle. The outcome of a latent condition dispute is usually determined by the contract, not simply by the existence of an unforeseen condition. So when reviewing construction contracts, particular attention should be given to the definition of the latent condition, notification requirements and time bars, entitlement to additional costs, entitlement to an extension of time, exclusion, disclaimers and reliance provisions, and investigation obligations before tender. Remember, a strong latent condition claim can still fail if contractual notice requirements are not followed. Okay, so here are some contract examples from AS 2124, the AIBC contracts, the GC 21 and the AS 4000. Each standard form defines latent conditions slightly differently, but from reading each one of those, they all rely on foreseeability and reasonable inquiries. The differences appear here to matter when assessing entitlement. Okay, so what are latent conditions? What's the objective standard for foreseeability? The Downer Construction vs Energy Australia case is about foreseeability. In this case, Downer encountered adverse soil conditions and claimed a variation and an extension of time. The court found the conditions were foreseeable based on pre-contract information, and the adjudicator's finding quoted on this slide, those features differed materially from the ground conditions that should have been anticipated by a prudent, competent, and experienced contractor. So the message is clear. Foreseeability is judged objectively. Contractors must review all information available. So just looking at what the tag boy summed up in the Downer case, ignorance is not a defence. Contractors must perform diligent inquiries. Okay, so what are the laws affecting latent conditions? Latent conditions and reliance on principal representations. So just turning back to the Walker case, what if it is reasonable for Mr. Walker to have relied on the plan? If you have a look at Section 18 of the Australian Consumer Law for misleading and deceptive conduct, a person must not, in trade or commerce, engage in conduct that is misleading or deceptive or is likely to mislead or deceive. The practical effect here is that If a party to a contract makes a representation about the site and that the other party relies on in entering into the agreement, and that representation turns out to be false, then the party who relied on the representation may have a claim under the Australian consumer law. So a case that considered a claim under the Australian consumer law is BMD Major Projects versus Victorian Urban Development Authority. In this case, BMD argued that Vic Urban's representations about fill quantities were misleading. The court confirmed that disclaimers cannot override the Australian consumer law, but BMD failed because they couldn't prove reliance. So the key line in the Victorian Court of Appeal is that exclusionary and disclaimer clauses cannot override the statutory prohibition against misleading and deceptive conduct. But you still need to prove reliance and causation. Okay, so just looking at another case, Doyles Construction versus Illawarra Hotel. This case is about a superintendent obligations under the AS 2124. The superintendent failed to grant reasonable extensions of time and undervalued variations. The issue was the principal in breach for failing to ensure the superintendent acted honestly, fairly, and reasonably? And could this lead to time being at large? The answer was yes. Justice McDougall held that the principal is liable because the superintendent's determinations were not reasonable. He said Walton could not be bound by her determination if that determination did not meet the description a reasonable extension of time. So what this case shows is that principals must ensure that superintendents act reasonably. Otherwise, the principal is in breach. In fact, that clear quote is important. Even if the superintendent had acted honestly and reasonably, Walton could not be bound by her determination if that determination did not meet the description a reasonable extension of time. If in any respect the superintendent failed to arrive at the reasonable measure of value, Illawarra has breached that obligation. Okay, so consultant liability for design-induced latent risks. The Land Code Council versus Davies case deals with consultant liability. Here, Land Code Council engaged Michael Davies to design a stormwater detention system. The construction revealed that the design failed to detect a latent subsoil water condition, resulting in instability led to project failure and damages. The issue was the design consultant negligent in failing to identify and advise on latent subsoil conditions? Was the risk foreseeable, and did it fall within the consultant's duty of care? The court here found that Davies breached its duty of care and that a competent consultant should have conducted or recommended adequate geotechnical investigations. So Davies was liable for council's loss arising from the failure to detect latent conditions. So the lesson here is simple. Consultants must recommend or conduct adequate investigations where latent conditions are foreseeable. So from the Trade Practices Act to the Australian Consumer Law. So the Trade Practices Act was overhauled, particularly Section 52 for misleading conduct. It's now Section 18 of the Australian Consumer Law. However, the case law under the Trade Practices Act continues to be relevant post 2011. And the core principle is misleading or deceptive conduct in commercial negotiation may override some of the contractual disclaimers. And statutory overlay provides broader remedies than the common law misrepresentation. So moving on to how statute and contract interaction in risk allocation. Contracts may limit claims, but cannot contract out of the ACL liability. If principle includes representations about the site or conditions, it must take care to qualify those statements. The court considers entire conducts in documents, not just contract clauses. Integration clauses are not a full defence if misleading conduct can be proven. So the statutory overlays, the ACL Section 18 applies regardless of the contract wording, and misleading conduct overrides those disclaimers and interrogation clauses. IQ related legal doctrines, frustration of contract, which we spoke about when we mentioned the Doyles Construction case. Frustration occurs when an unforeseen event renders contractual performance radically different. It's rare in construction, as the courts expect the parties to allocate risks. They must not be self-induced, cannot be invoked where the contract provides for risk. As explained in Cadelpha was restricted from night works due to an injunction after works began. The contract was frustrated, and the unexpected injunction made timely performance impossible. Okay, so another important incident case in the space, Probuild versus DDI, discretionary extension of time powers. Here, Probuild had discretionary power to grant extensions of time, even without a claim. DDI missed the time bars, but Probuild didn't exercise its discretion. And the issue was Probuild obligated to exercise its discretionary EOT power despite no probable claim by DDI? And was there an implied duty of good faith to require action? The New South Wales Court of Appeal held that Probuild was obliged to exercise its discretion fairly and honestly, and that a failure to do so would breach its implied duty of good faith and trigger the prevention principle. So this particular case reinforces the prevention principle, which is principals must not benefit from their own failure to act. So contracting with latent conditions. The courts consider all material circumstances when sort of pricing, variations. And the court must have regard to all material circumstances. As set out in Lucas Earthmovers versus Anglo-Gold Ashanti, this case deals with the pre-agreed variation rates. The court said that when determining reasonable rates, all material circumstances must be considered, including time-related costs. And just looking at the quote, the court is to have all regard to all material circumstances. And so this becomes important when pricing on latent conditions variations. So foreseeability, the objective versus subjective tests. The courts apply an objective test, which is what would a reasonably competent contractor have foreseen given the available information? And subjective lack of knowledge is not sufficient. Foreseeability is assessed by reference to the tender document, the site inspection, industry knowledge, and inquiries made pre-contract. So really, it's based on what a competent contractor should foresee from the available information. So establishing causation for latent condition claims. A contractor, in order to succeed, must prove that a latent condition existed, that it wasn't foreseeable, that it caused cost or delay, and it satisfies the contractual and legal entitlement clauses. So causation often hinges on the contemporaneous site reports, delay analyses, and expert reports. It's really the contract that gives that entitlement. The reliance on tender and pre-contract representations. Often contractors rely on geotechnical reports and soil data and consultant findings in their tender base. But to succeed in a misrepresentation or misleading conduct claim, the contractor must prove that reliance was reasonable the principal had knowledge or failed to disclose the contrary information, and that the reliance caused the loss. So carefully crafted disclaimers and due diligence obligations may prevent such claims. And so contractors, be often reliant on the geotech reports and the tender data. In order to succeed, reliance must be reasonable and must have caused that loss. All right, so how do we quantify time and cost impacts of latent conditions? So cost impacts: extra excavation, stand down time, additional plant labor and materials. And some of the time impacts include delay to the critical path, program sequencing, and flow-on effects from contractors to subcontractors. So cost and time impacts must be evidenced, and the critical path delay analysis is essential. Okay, so what type of expert evidence do we see in latent condition disputes? So geotechnical experts validate the existence of unforeseen ground conditions. Programming experts establish EIT claims through delay analysis, as claimed versus as built. And quantity surveyors assist with cost quantification. It's really important that the expert evidence be independent, based on objective analysis, and consistent with the contractual framework. The other thing to notice is that the geotech, programming, and QS experts, they're crucial, and their evidence must align with contract. The notification obligations and time bars. Most contracts require notice within a strict time frame. So the examples are 14 days. And a failure to comply may actually bar the claim entirely if the clause is a condition precedent, or the failure to comply may prejudice the principal. And the courts increasingly uphold time bar clauses if clearly drafted, as Probord and DDON. And some of the key tips in terms of notification obligations is to issue early notice with reservation of rights and provide follow-up with supporting detail. So I guess the takeaway is that most contracts require the strict notice. The failure may bar a claim, and the courts are increasingly upholding time bars if clearly drafted. All right, practical tips and checklists. So how to draft the effective latent condition clauses. It's really important to clearly define a latent condition and trigger events. It's also important to set procedures for notification, inspection, and entitlement. The contract should also state how costs and time impacts are assessed, and allocate who bears the risk of particular types of conditions. Also, it's important to include baseline site data as a part of the contract. So clear definitions, procedures, entitlements, and baseline data make the latent condition clauses effective. All right, a contractor due diligence checklist. 1, conduct a thorough site inspection. Review geotechnical and historical data. Analyze utility records and survey plans. Engage in geotechnical experts if needed, pre-tender, and confirm assumptions and qualifications in the bid. So contractors must inspect the site, review the data, analyze utilities, engage experts, and qualify assumptions. Okay, so that's the contractor. What about the principal? The principal should provide all material site information in possession, identify what site conditions are assumed in the design, avoid selective disclosure, and ensure geotechnical contamination reports are current, and include disclaimers where appropriate but not misleading. So overall, principals must disclose all information, avoid selective disclosure, and ensure all reports part. What about contract administrators? They form a very important role in early detection. So contract administrators such as superintendents should monitor construction of sites for signs of latent conditions early. They should ensure that notification provisions are complied with, that accurate records and photo evidence are kept, that they facilitate independent assessments of latent condition claims, and that they may maintain fair and impartial treatment of such claims. So it's on the superintendent or contract administrator to detect the issue early and ensure that the notices are issued, also keep the records and treat claims fairly. So managing claims, the process, evidence and communication. I think this is one for construction participants. It's important to acquire prompt and detailed notices from contractors, maintain site diaries, drawings and sample logs, use agreed methods for quantification, perhaps such as cost codes, engage experts early if needed, and maintain transparent and respectful communication. So in managing claims, prompt notice, strong evidence, agreed quantification methods, and early expert engagements are key. Okay, so engaging experts effectively. Use experts with clear scope aligned to contractual requirements. So there's emphasis on the use of independent court experience experts. Where disputes inevitably escalate to court, if you've acquired reporting that doesn't comply with the expert witness code of conduct adopted by the courts, acquired by the courts, then there's always going to be a risk that you may have to have those reports read. Principals disclosure obligations checklist. Provide material site information in possession. Identify what site conditions are assumed in design. Avoid selective disclosure. Ensure geotechnical and contamination reports are current, and include disclaimers where appropriate but not misleading. So overall, principals must disclose all material information, avoid selective disclosure, and ensure reports are current. So the role of contract administrators, it's important for superintendents and contract administrators to detect issues early and ensure notices are issued and records are kept in order that claims are treated fairly. So the 5 points are: monitor construction for signs of latent conditions early, ensure notification provisions are complied with, keep accurate records and photo evidence, facilitate independent assessment, and maintain fair and impartial treatment of claims. So how to manage claims, the process, evidence and communication, prompt notices, strong evidence, agreed quantification methods, and early expert engagement are key. So the 5 things to keep in mind are: require prompt and detailed notices from contractors, maintain site diaries, drawings and sample logs, use agreed methods of quantifying impacts such as cost code, engage experts early if needed, and maintain transparent and respectful communication. So engaging experts effectively, use independent court experience experts. It's really important that if a dispute is likely to be escalated to court, that compliance with the court's expert witness code of conduct is a general requirement. And so briefing early experts who are independent and who can adhere to those codes is important. It's also important to define a scope early and clearly. So site inspection, reporting and opinion scopes also critical. And it's important to ensure expert aligns findings to contractual clauses. So the message here is: use independent experts with clear scopes aligned to contractual requirements. So what are the common pitfalls and risk management tips? Failing to give timely notice, incomplete or poor site investigations, overall reliance on early reports without validation, and assuming risk allocation is balanced without checking clauses. So in terms of late notices, poor investigations, over-reliance on early reports and assumptions about risk allocation, those are the things that we find get principals, contractors into hotly contested debates. And so avoiding those things is critical. Okay, so a really important one, when to call a lawyer. Call a lawyer when you encounter a latent condition, when you can't investigate it properly, or when a principal rejects your variation. So if for whatever reason you can't investigate the site for the issues discussed, that is, you're prevented from undertaking the investigations, or you're just unsure in terms of which experts you might need to engage, or who's the most appropriate person or persons to conduct those investigations, or the lawyer. And when you encounter a latent condition of a type contemplated, so it's common that we're contacted when principals reject variations for latent conditions. And it's also important to consider the commercial considerations. So what are the implications of the latent condition on the project? Both as to cost and timing. Inevitably, things cost more, and it's usually getting the approval for those additional costs, which causes delay. Sometimes projects are on standby as a result of the debate between whether a principal accepts a variation for a latent condition or not. All right, okay, so that concludes my presentation. If you've got any sort of follow-up questions or queries, feel free to contact us. Thanks for your time.